Alright. All right, it's April 6, 2017. Labor Management Report Disclosure Act of 1959 is amended, revised text shown in amended language, boldface type. Public Law 86257, September 14, 1959, Statute 73, Statute 519, 519 through 446. Public Law 89 through 89, 216, September 29th, 1965, Statute 79, Statute 888. Public Law 98, 473, October 12, 1984, 98, Statute 2031, 2033, 2133, 2134, Public Law 99, 217, December 27, 1985, 99, Statute 1728, Public Law 100, 182, December 7th, 1987, 101, Statute 1266, 1269. Alright, an act to provide reporting disclosure certain financial, translation, administrative practice of a labor organization employed to prevent abuse for the administrative of the trustees. Labor organization to provide standard with respect to the election of the labor organization for other purposes. Be enacted with the Senate House of Representatives of the United States of America, Congress, and assembled. This act may be cited with the Labor Management Reporting Disclosure Act of 1959. The information for the public may be available in alternative formats upon request for information. Call 202-693-0123. Toll-free users may call this number through relay services. Alright, Labor Management Report Disclosure Act of 1959 is amended, finding policy definitions, equal rights, freedom of speech and assembly, dues, initiation fees, assessment protection right for the safeguard against improper disciplinary action, civil enforcement, retention of existing rights, copy of the collective bargaining agreements, information as act, bills of rights for the union members, reporting requirements, report of labor organization, report of union officers, employees, report of employee or labor relations consultant, attorney, civil client privilege, reports made with the public information retention records, effective dates, rules and regulations, criminal provisions, civil enforcement, surety company reports. Title III, Trusteeship, reports, purpose of the trusteeship's unlawful act with the trustees, enforcement, reports of the Congress compliant by Secretary. Title IV, Election Officers, Terms, Election Procedures, Enforcement, Application of Other Laws, Effective Date, Set. Title V, Safeguard Labor Organization, Fiduciary Responsibility of Union Officers, Bonding, Loans, Payment, and Fines, Prohibition Against Holding Office, Amendment, Section 302, Labor Management Relations Act of 1947. Title VI, Miscellaneous Provisions, Investigation, Retention Rights of under other federal, state, and laws, effective on state laws, Service Process, Administrative Procedure Act, other agencies, departments, criminal contempt, prohibition of certain union disciplines, deprivation rights, violence, severability provisions. Title VII, Amendments to Labor Management Relations Act of 1947, amendment of the text of Section 701 through 707 is not included herein. However, the complex text of the Title VII Amendment for the Labor Relation Act of 1947 is amended may be found in Public Law 86257. Our definition of finding the purpose of the policy. Section 2 of the Congress finds that the public interest and continue the responsibility of the federal government, particularly employees' rights, but the organized choose their own representative, bargaining collectively, otherwise engage in concerted activities for mutual aid and the protection of the relations between employers, labor organization, millions of workers they represent with a substantial impact with the commerce of the nation, that in order to accomplish the objective of free flow of commerce, is essential for the labor organization employer, their officials adhere to the highest standards of responsibility, ethical conduct for the administrative of the affairs of the organization, particularly with the effective labor management relations. B. The Congress further finds for the recent investigation of labor management fields there have been a number of instances of breach of the trust, corruption, disregard of the rights of the individual employees. Other failures to observe high standards of responsibility, ethical conduct will require further supplementary legislation that will afford necessary protection for the rights and interests of the employees and the public generally as they relate to activities of the labor organization, employer, labor relations consultant, their officers and representatives. The Congress therefore further declares an enactment of the act is necessary to eliminate to prevent improper practice for the part of a labor organization, employer, labor relations consultant, their officers, representatives, to distort and defeat the policy of the Labor Management Relations Act of 1947 as amended with the Railway Labor Act as amended with the high tendency necessary effect of the burdening and obstruction commerce, one impairing the efficiency, safety, operation, instrumentally with the commerce, occurring with the current commerce, and then materially effective with the restraint with the control of flow of the rate of raw materials manufactured, processed good into the flow from from, channeled with the commerce and price with such of the material goods and commerce, causing diminution of employment wages and such volume substantial to impair the disrupt the market of goods from flowing into and from the channels of commerce. Our definitions, Title 29 U.S. Standard Code 402, Section 3, for the purpose of Title 1, 2, 3, 4, and 5 exceptions, exempt Section 505, Title 6 for the amendment of the commercial man in the trade with the traffic, commerce, with the transportation, transmission, communication among several states between the state and a place outside thereof. State includes any state of the United States, District of Columbia, Puerto Rico, Virgin Islands, American Samoa, Guam, Wake Islands, the Canal Zone, Outer Continental Shelf land, defining the Outer Continental Shelf Land Act, Title 43 U.S. Standard Code 1331, 1343 through 1331 through 1343. Industrial affecting commerce means the activity of business, industrial commerce in which the labor dispute with infrastructure commerce with the free flow of the commerce, including any activity industry affecting the commerce, the meaning of the Labor Management Relations Act of 1947 as amended, but the Railway Labor Act is amended. Person includes one or more individual labor organization, partnership, association, corporations, legal representative, mutual company, joint stock companies, trust, incorporated organization, trustees, trusteeship, trusteer, in cases under Title 11, United Standard Code 2, noted 2, receivers, employers means any employer, any group of the association employers engaged with the industrial affecting commerce, while which with respect to employees engaged with the industrial activity affecting commerce, an employer with the meaning of the law of the United States relating to the employee with the employees which legally deal with the labor organization concerning the grievance, labor disputes, wage rates, pays, rate of pay, the hours of employment, condition of the work, including any person acting directly and indirectly as an employer, as an agent of the employer, and relating to the employee, but does not include the United States of any of the corporation wholly owned by the government of the United States and any other political subdivision thereof. Employee means an individual employed by the employer and includes an individual whose work has ceased consequences of connection with the current labor dispute because of the unfair labor practices, because of the exclusion and expulsion of the labor organization in any manner or for any reason inconsistent with the requirements for the Act. Labor dispute includes the controversial concerning tenure, conditions, employment concerning the association, representation, person in negotiating, fixing, maintaining, changing, seeking to arrange terms, condition, employment, regardless of whether the disputants stand in an approximate relationship with the employer. The trusteeship means the receivership of the trusteeship, other the method of the supervision and control with the labor organization suspended autonomously, otherwise available to the subordinate body under the constitutional law. 1. Labor organization. Labor organization means that any organization engaged in the industry affecting the commerce includes the organization of any kind of agency, employee representation, committee, group, association, or plan so engaged with the employees to participate, which exists for the purpose in whole, in part, of dealing with the employers concerning with grievance, labor disputes, wages, and rates for the power, paid hours, or other terms, condition with the employment, any conference, general committee with the joint and system board with the joint council, and so engaged with the subordinate national, international labor organization other than state and local signing or body. A labor organization shall be deemed engaged with the industrial affecting the commerce if it is certified representative of the employee under the provision of the National Labor Relations Act as amended with the Railway Labor Act as amended although not certified a national, international labor organization, local labor organization recognized an acting representative of the employees and employer engaged with the industrial affecting commerce. 3. Has chartered with the local labor organization subsidiary body with the representing actively seeking to represent employees and employers with the meaning of the paragraph 1 and 2. 4. Has chartered with the labor organization representing with the actively seeking to represent employees with the meaning of the paragraph 1 and 2 of the local subordinate body with which such employees may enjoy membership and become affiliated with such a labor organization. Or 5. In the conference, general committee, joint and system boards, a joint council supported with the national and international labor organization, which includes labor organization engaged with the industrial affecting the commerce with the meaning of any of the preceding paragraphs of the subsection of the other state and local central body. K. Secret ballot means an expression of the ballot voting machine or otherwise no evident by proxy choosing with the representative election and vote with the take upon any matter which is the cast such as manner with the person expressing such choice cannot be identified with the choice expressed. L. Trust in which the labor organization is interested means the trust or other fund with the organization created with the established labor organization, one or more of the trustees or one or more of the members of the governing body was selected with the appointed labor organization to the primary purpose of which provided with the benefits for the member of such a labor organization beneficiary. I am labor resolution consultants, meaning of the name person for the compensating advisor, the representative of the employer, employer organization, labor organization, concerning employee organization, concerted activities, collective bargaining activity. Officer means the constitutional officer, any person authorized to perform functions of president, vice president, secretary, treasurer, or other executive function of labor organization. Any member of the executive board similarly govern the body. Be the member in good standing when used in reference to the labor organization includes any person who has fulfilled the requirements of membership in such an organization who neither voluntarily withdrawn with the membership nor has been expelled, suspended for the membership after the appropriate succeeding proceedings consisting with the law provisions of the Constitution by such of the organization. Secretary means the Secretary of Labor. Q. Officer, agent, shop, steward, or other representative when used with the respective labor organization include elected officials, key administrative personnel when elected appointed with such business agents, head of the department's major units organized with the exercise substantial and independent authority but does not include the salaried and non-supervisory professional staff, the stenographer, and service personnel. Our District Court of the United States means the United States District Court of the United States Court of any place subject to the jurisdiction of the United States. Alright, Title 1, Bill of Rights of the Member of the Labor Organization. Bill of Rights, Title 29, U.S. Standard Code 411, Section 101, Equal Rights. Each member of the labor organization will have the equal rights and privileges with such organization nominated with the candidate vote, elections, referendums of the labor organization to attend membership meetings, to participate in deliberation, voting upon the business such meetings subject to reasonable rules, regulations, such organization constitutes by law. Freedom of the speech and assembly. Each member of the labor organization shall have the right to meet with the assembly freely with the other members to express view, arguments, for the opinions to express the meetings. The labor organization his view upon candidates in election. Labor organization upon any business properly being for meeting and subject of organization establishing reasonable rules pertaining to the conduct of meeting and provided that nothing herein shall be constituted impaired with the right of the labor organization adopt and enforce responsible rule for the responsibility of any member toward the organization institution to his refraining from the conduct that would interfere with the performance of legal contractual obligations, dues, and initiation fees and assessment, except in the case of Federation of the National and International Labor Organization. The rate of the dues and initiation fees payable by the members of any labor organization effective with the enactment of the act should be increased. No general special assessment should be levied upon such members, except in the case of local organization. 1. The majority of the secret ballot of the members of the good standing vote for the general special membership meeting thereafter reasonable notice for the intention of the vote upon such question. 2. The majority of the vote of the members in good standing the voting of the membership referendum conducting by a secret ballot. B. In any case of the labor organization other than the local organization, Federation, National, International, local organization or organizations. B. The majority of the vote of delegates voting in the regular convention at or some special convention such labor organization held about not less than 30 days written notice of the principal office of each local constitution labor organization entitled with such notice. 2. The majority of the vote of the members good standing such labor organization voting with the membership referendums by secret ballot. 3. Majority of the vote of the members of the executive board, similar governing board for such organization pursuant to express the authority contained in the constituted bylaws of such a labor organization, provided that the action of any part of the executive board similar governed by shall be effective only until the next governing regular convention or such labor organization. 4. Prevention of the right to sue. No labor organization shall have the right to the member, therefore, institute any action in any court proceeding before the administrative agency, respectively, whether or not the labor organization or its officers are named defendants or respondents in such action, perceive the right of any of the member labor organization to appear with the witness in judicial, administrative, legislative proceeding, to petition any legislator, communicate with the legislator, provided that any such may be required to exhaust reasonable hearing procedures, but not exceed 4 month lapse on time within such organization, institute legal administrative proceedings such as organization of any of the officers, and provide further that no interested employer association should directly and indirectly finance, encourage, or participate expect as party any such action, proceeding, appearance, petition. Safeguard against improper disciplinary action. No member of any labor organization may fine, suspend, expelled, otherwise disciplined, except for the non-payment of the dues, such as organization of any of the office thereof, unless such member has been A. served at the written specific charge, give them reasonable time for the prayer of the defense. C. afford a full and fair rehearing. Any provisions constituting laws or labor organization with consistent provision section shall be no force effective. Alright, civil enforcement. Title 29 U.S. Standard Code 412, Section 102. Any person who writes to carry with the provision of the title have infringed violation of the title may bring the civil action of the District Court of the United States for such relief, including injunctions as many and appropriate, and such actions against the labor organization will be brought in the District Court of the United States for the district where the alleged violation occurred when the principal of such labor organization is located. Retention of existing rights. Title 29 U.S. Code 413, Section nothing constituted containing but the title limit shall write the remedies for the member of the labor organization under state and federal law before any court or other tribunal under the Constitution and bylaws of any labor organization. Rights to copy collective bargaining agreement. Section 104. It shall be the direct duty of the secretary corresponding with the principal office for each labor organization gave to the local labor organization for the forward a copy of the collective bargaining agreement may be then such organization employer that any of the employee requests such a copy with the rights of such employee that directly affected with such agreement, and in the case of the labor organization, other labor or local labor organization to forward a copy of such agreement to each constituting union with a member that is directly affected with such agreement. Such officer shall maintain in principle of the labor organization which he is an author of the copies in such an agreement made proceed with such labor organization with the copies shall be available for inspection. Any member of any employee who rights affected with such agreement, the provisions section 210 shall be appropriate in enforcement of this section. Information as to Act. Title 29 U.S. Standard Code 415. Section 105. Every labor organization shall inform its members concerning the provisions of this Act. Title 2. Reporting labor organization officers, employees, and labor organization's employer. Report of the labor organization. Title 29 U.S. Standard Code 431. Section 201. A. Each labor organization shall adopt and constitute bylaws, shall file a copy thereof the secretary together with report and signed by President, Secretary, corresponding principal officer containing the following information: the name of the labor organization, mailing address, any other address which maintains the principal officer, which keeps the records referred to the title, the name of the title of effect of each officer, the initiation fee required for the new transferred member of the fees, work permits required for the labor organization, regular dues and the other periodic payments required to remain the member of the reporting labor organization. 5. Detailed statement of the reference specific provision documentation filed under the subsection which contains such statement showing the provisions made with the procedure filed with respect to each of the following: A. Qualification restriction for the membership, levying of the assessment, participation, insurance, or other benefit plan. The authorization, disbursement funds of the labor organization. E. The audit of the financial transaction labor organization. F. The calling for the regular special meetings. G. The selection of officer, steward, and if any representative other than the body composed of the labor organization representatives with specific statement of the manner in which each of the officer was elected and appointed. Otherwise, H. Discipline, removal of the officers, agents for the breach of the trust, imposition of the fines, suspension, exclusions of the member, including the grounds of such action, and provision made with the notice, hearing, and the judgment of the evidence and appeals procedure. J. The authorization bargaining demands. K. The ratification of the contract terms. L. Authorization of strikes. And M. Is issuance of the work permits. Any change of the information required by the subsection shall be reported in the Secretary at the time reporting labor organization with the Secretary annual financing report required in subsection B. B. Every labor organization shall file annually with the Secretary of the financial report signed by the President, Treasurer of the corresponding principal office containing the following information. Such detailed that it may be necessary accurately to disclose the financial condition and operation with the preceding fiscal year. 1. The asset liability at the beginning of the end of the year or fiscal year. The receipt of income, the source thereof. The salaries and allowances of the direct and indirect disbursement, including the reimbursement expenses to each officer. Also, each employee who during the such fiscal year received more than $10,000 in aggregated from such labor organization, any labor organization affiliated with it, or with which is affiliated with such a national, international labor organization. 4. Direct and indirect loans made by any officer or employer, the members which aggregated more than $250 during the fiscal year together with the same in the purpose of the Secretary, if any of the arrangements for repayment. And 5. The direct and indirect loans of any business enterprise together with the same in the purpose of the Secretary within the arrangements for repayment. 6. The other disbursement made to include the purpose thereof, and such categories and Secretary may be prescribed. See, every labor organization required to submit a report under the title shall be made available the information required to contain such a report, that all the members, each of the labor organization officers, shall be under the duty enforceable at the suit of the member of such organization in the state of the court with the competent jurisdiction of the District Court of the United States for the district in which such labor organization maintains the principal office to permit the member to just govern to examine a book of records accounts necessary to verify such a report. The court is in such action made with discretion in addition with the judgment awarded to the plaintiff, allowing to the reasonable attorney with the fee paid with the defendant cost of the action. B. D. The section F, G, and H, the section 9 of the National Labor Relations Act amendment that hereby repealed. E. Clause 1 of section 8A, 3 of the National Labor Relations Act is amended with the amended striking out the following yet, and has the time for the argument the time at the agreement was made with the preceding 12 months received from the Board of the Notice of Compliance with section N, 9, F, G, and H. Report officers and employees in labor organizations, Section 202, Title 49, Title 29 U.S. Standard Code 432, Section 202. Every officer of the labor organization, every employee with the labor organization other than employee performing exclusively clerical custodial duties shall file with the Secretary signed report listing with describing the hit of his proceeding fiscal year. Any stock, bond, security, other interest, legal, equitable with his or her spouse, minor child, directly, indirectly held in income, any other benefit, monetary value, including reimbursed expenses, while he or his spouse or minor child derived directly, indirectly from the employer whose employee such labor organization represents, actively seeking the existing payments and other benefits received as a bona fide employee of such employer. Alright, 2. Any of the transaction which his or her spouse, minor, child engaged directly and indirectly involved in the stock of the bond security of the loan is to affirm a legal, equitable interest of the business. Any employer who employs such a labor organization represented and actively seeking represent. 3. Any stock, bond security, other interest, legal, equitable, which his or her spouse, minor, child directly and indirectly held in any of the income, any other benefit of monetary value, including reimbursement expenses which he or his or her spouse, minor, child directly and indirectly derived from the business, substantial with which consists of the building itself, leasing, or otherwise dealing with a business and employer or whose employees such a labor organization represents actively seeking to represent. 4. Any stock, bond, security, other interest, legal, equitable, which he is or her spouse, minor, child directly, indirectly held in any income other than benefit, monetary value, including reimbursed expenses, which he or his spouse, minor, child directly, indirectly derive the business at any part of the existing buying from selling or leasing directly, indirectly, otherwise dealing with such labor organization. 5. Any direct or indirect business transaction agreement between him or his spouse or minor child and an employer with an employee with his organization actively seeking to represent, accept work, perform payments of the benefit received with the bona fide employee of such employer, exempt purchase of such sales of goods and serve the regular course of the business as prices generally available to any of the such employer. 6. Any payment part, money other than value, including reimbursement expenses which he or her spouse, minor, child received directly, indirectly, any employer, any but the person who acts labor relations consultant, employer accept payments of the kind referred to Section 302 of the Labor Management Relations in the 1947 Act. B. The provisions of paragraph 1, 2, 3, 4, and 5, subsection A, shall not be construed to require any such officer employed to report bona fide investment security, third trade with the Security Exchange for registered as National Security Exchange with the Security Exchange Act of 1934, shares investment company registered with the Investment Company Act. Alright, A shall not be construed with any such officer employed to report the bona fide investment security trade with the Security Exchange registered in the National Security Exchange with the Security Exchange Act of 1934, share with the Investment Company registered with the Investment Company Act, the Security of the Public Utility Holding Company registered on Public Utility Holding Company in the Act of 1935, report to the income derived thereof. Nothing contained in the section shall be construed to require an officer employed with labor organization file a report under the subsection A unless his or her spouse, minor, child holds and has held an interest and has received income or any other benefit, monetary value of the loan and is engaged with the transactions described therein. A report of employers, Section 203, Title 29, U.S. Standard Code 433. Every employer who has an official year made with any of the payment load and directly, indirectly money with other thing of the value, including reimbursement expense, any promise and agreement of therefore labor organization, officer, agent, should other representative labor organization employed with any labor organization, except any payments of the loan may be national stock, state bank, credit or union, insurance company, savings and loans association, credit institution, be many with the kind that referred to in Section 302 of the Labor Management Relations Act of 1947 Act as amended. To any payment including the reimbursement expenses to as employees in group of the committee with such employees for the purpose of causing such employee group of the committee with employees to persuade other employees to exercise, not to exercise as a manner of exercising the right to organize, bargain collectively through the representative of their own choose, unless such state payment is contemporaneously previously disclosed to such other employees. Through an expenditure during the official year with the object thereof directly and indirectly interfere with the restraint and the coerce with the employees in their exercise the right to organize, bargain collectively through the representative of their own choosing to obtain information concerning the activities of the employee labor organization connecting the labor dispute involving such employer, except that use is solely conjunction with the administrative of the arbitral proceeding of the criminal civil judge proceeding for any agreement arrangement with labor relations consultant or other independent contractor organization pursuant to which such a person undertakes activity where the object thereof directly and indirectly so is to persuade employees to exercise, not exercise, persuade employees in manner exercising right to organize, bargain collectively through the representative of their own choosing, undertakes supply of such employer information concerning the activities of the employee's labor organization connecting the labor dispute in such an employer accept the information solely in conjunction with the administrator, arbitral proceedings, and civil, criminal, and civil justice proceedings. 5. Any payment, including reimbursed expenses pursuant to the agreement of the arrangement described in subdivision 4, shall be the secretary with the report form prescribed by him, signed by its president, treasurer, corresponding principal officer, showing detailed date and amount of each of such payment, loan, promise agreement, arrangement with the name, the address, and position, if any, with the firm, law, organization, person who have been made with the full explanation of the circumstances. All such payments include the terms of the arrangement and understanding pursuant to which they were made. B. Every person who, pursuant to the agreement arrangement within the employer undertakes activities where the object there is, directly or indirectly, 1. Persuades the employer to exercise, not to exercise, to persuade employees to manner exercising right to organize, bargaining collectively through the representative of their own choosing, to supply an employer information concerning the activities of employer, labor organization, connection, labor dispute involving such employer, except for the information using solely in conjunction with the administrative, arbitral proceeding, criminal, and civil judicial proceeding. Shall file within 30 days after entering the arrangement of the agreement or arrangement with the report of the secretary signed with the president, treasurer, corresponding with the principal office, containing with the name of such of the person that is engaged in the doing the business, addressed with the principal office, detailed statement of the terms and conditions of such arrangement or agreement. Every such person shall file annually with respect to each of the file officially during the payments where they are result in such agreement, arrangement, or report of the secretary signed with the president and treasurer, corresponding principal officer, containing statement A of the receipts in any kind of the employer's account with labor or relations that can advise on services designated for the source thereof. B. Of the disbursement any kind of connection with such services, purpose thereof. In any such case, the information shall set forth in such categories. Secretary may subscribe. Or is there nothing in this section shall construe to require an employer or any other person to file the report covering services of such person. Reason for his giving an agreement to give the advice of such employer, representing an agreement to represent such employer before any current administrative agency, tribunal, or arbitration, agreeing to engage with the collective bargaining on behalf of such employer with respect to wages, hours, or other terms, conditions, such employee negotiation of the agreement, any question arising thereof. Under nothing contained in this section shall construe to require an employer to file the report under subsection A, unless he has made an expenditure, payment, loan, agreement, arrangement with the kind described therein. Nothing contained in this section should construe to require any other person to file the report under subsection B unless he was a party in an agreement to arrangement of the kind described therein. Alright, E. Nothing contained with the subsection constructed with the required regular office supervisor employer to file the report in connection with the services required of such employers, nor such employer with the required to file a report cover the expenditure made to the regular officer, supervisor, employer, any employer compensation for service of regular officer, supervisor, employee, and such employer. Nothing contained in the section construed with the amendment of modification of rights protected in section 8C National Labor Relations Act as amended. The term interfere with the restraint and coerce are used in the section means interference, restraint with coercion, which the done with respect to the exercise right guaranteed in section 7 National Labor Relations Act and attended with under the subsection 8A of such act constitute unfair labor practices. Alright, attorney-client communication expected. Title 29 U.S. Standard Code 434. Section 204. Nothing contained in this act shall be construed as required to the attorney who is a member of the good standing of the bar in any state, include any report required to the file pursuant to provisions of the act. Information with lawfully communicate with such attorney by any of the clients in course of a legitimate and attorney-client relationship. Alright, reports made public information, Title 29 U.S. Standard Code 435, Section 205 of the contents of reported documentation filed with the Secretary pursuant to Sections 201, 202, 203, and 211 should be public information. Secretary may publish the information and data that obtained with the pursuant to provision of the title. Secretary may use the information and data statistical research purposes comply with the published studies, such studies, analysis, report, surveys based thereon, and may be deemed appropriate. Secretary shall be regulated by the reasonable provision of the inspection, examination, request of the person, the information data contained in any of the report, other documentation filed pursuant to Section 201, 202, 203, and 211. The Secretary shall regulation provide with the furnish the Department of Labor to copy the reports and other documents filled with the Secretary pursuant to the title upon the payment of the charge based upon the cost of the Secretary. The Secretary shall make it available with the payment of the charge, require any person to furnish the state of the agency designated by law or governor or of the state in which such a person has a principal place for the business and headquarters upon the request of the governor of such a state copies of any of the reports documents filed such a person within the Secretary pursuant to section 201, 202, 203, and 211 for information data contained there. No person shall be required reason of any law, any state to furnish any other agencies state information included the report filed with such person state secretary pursuant to the provision titled with a copy of such reports portion therefore containing such information furnished to such officers all money received the payment such charges affixed by the security pursuant to the subsection and shall be deposited in general fund of the treasury. All right, retention of records, Title 29 U.S. Standard Code 436, Section 206. Every person required to file under this title shall maintain the records of matters required to be reported, provided with sufficient detail with the necessary basic information data from with the document filed with the Secretary may verify and explain and clarified, checked for accuracy, completeness, and shall include vouchers, worksheets, receipts, applicable resolutions. Shall keep such record available for the examination period not less than 5 years after the filing of the documentation based on which they can contain. Effective date, Title 29 U.S. Standard Code 437, Section 207A. Each labor organization shall file initial report required on Section 201A within 90 days after the date of which it becomes subject to this Act. B. Each of the person required to file a report under the subsection 201B, 202, and 203A. The seconds of Section of 203B and Section 211 shall fill with such a report the 90 days after the end of each of the official year, except with where that such a person is subject to 201B, 202, 203A, and second sections of 203B in Section 211, as in the case may be for any of the portions of such official year, may because of the date of the enactment act, if the occurs during such a person official year, such a person becomes subject to the act during the official year, such person may consider the portion of the entire official year in making such report. Rules and Regulations, Title 29, U.S. Standard Code 438, Section 208. Secretary shall have the authority to issue, amend, with resign rules, regulation, performing the informal publication reports required to be filed under this title with some other reasonable rules, regulations, including rules, report processing reports concerning trusts which labor organization is interested in have may be necessary to prevent circumvention or evasion of such requirements. In exercising his power under the section, the Secretary shall prescribe the general rule simplified reports of labor organization employer for whom finds that the virtue of the side of the detailed report unduly burdensome by the Secretary may be revoke such provisions in simplified form that any labor organization employer that determines after such investigation has deemed proper to do the notice opportunity for the hearing the purpose of the section would be served thereby. Alright, criminal provisions, Section 209, Title 29, U.S. Standard Code 439, Section 209A. Any person who willfully violates the title shall be filed not more than $10,000 in prison, not more than 1 year, or both. Any person who makes a false statement, representation material, knowing that it to be false, and knowingly fails to disclose the material fact, any documentation, report, or other information required for the provisions of the title shall be fined not more than $10,000 prison from not more than 1 year, or both. Any person who willfully makes a false entry, willfully conceals, withholds, destroys any books, records, reports, statements required to be kept by any provisions of the title shall be fined not more than $10,000 in prison for not more than 1 year, both. Each individual required to sign the reports under Section 201, 203 shall be personally responsible for filing such reports for any statement contained therein with notice to be false. Alright, Section Civil Enforcement, Section 210, Title 29, U.S. Standard Code 440. Whether shall appear with any person violated support about to violate any of the provisions of the title of the Secretary may bring a civil action for such relief, including injunctions as may be appropriate. Any such action may be brought in the District Court of the United States where the violation occurred with the option of the party of the United States District of the Court of District of Columbia. Alright, surety company reports, Title 29, U.S. Standard Code 441, Section 211. Each surety of the company which issued any of the bond required by this Act, Employee Retirement Income Security Act of 1974, shall file annually Secretary with respect of the each fiscal year during with any such bond was in force or report in such form detailed as may be prescribed with the regulation filed by the President and Treasurer and corresponding with the principal of the surety company describing the bond experience under each of such Act, including information as to the premiums received, total claims paid, amounts received, recovered by subrogation, administrative, legal expense, such related to the data information. Secretary shall determine the necessary public interest to carry out the policy of Act. Notwithstanding the foregoing, Secretary finds that any specific information cannot be practical or certain would be uninformative. The Secretary may be mounted to waive the requirement for such information. Or Title III trusteeships.